Good morning, everyone. We're going to make a start pretty soon. There are a couple of chairs still at the front. Please fill them up rather than standing. Amazing. Well, I'm going to make a start. Good morning, everybody. Welcome to this session. It's fantastic to see a full room. So really excited about this session that we're bringing to you today. The reason for the session is to discuss litigation in our world of knowledge exchange and technology transfer, which is something that doesn't happen all that often. And an awful lot of what we've heard over the last couple of days is all of the wondrous and various ways in which we can engage with our external communities and the business world and make new things happen. But sometimes those partnerships don't end up cantering off into a glorious sunset. Sometimes it gets a bit more difficult, and sometimes it ends up in court, which is what we're going to talk about today. So I make no apologies. There's going to be quite a lot of law in this session. I know that we've got some people in this room who are absolutely comfortable with that and qualified. I also suspect that we're going to have some people in the room who are not so familiar. I trust Tess, who is talking, to make complicated things really comprehensible. She's pulling a funny face at me now. But you know, I want this to be a session that's accessible for everybody. So if there's any terms or anything that you don't understand, please do stick your hand up and say so, and we'll try and explain as we go. So, you know, litigation in the UK is quite unusual in our sector. This is the first real bit of case law involving a university spin-out company that's happened. There is more litigation in the States. It does happen from time to time. It's not frequent. But so is it rare? Yes. Is it inevitable? Probably also yes, as the volumes start to rise, as some of the amounts of money involved start to rise. So it's better, in my view, to learn about it and prepare yourself and expect it, so that if it ends up going there for you in your institution, you've got at least some view of what's going to come. So the structure of our session today, we're really delighted that we've got Tess Waldron, who is my instructing solicitor from the legal case. Tess is going to walk us through the case in a few minutes. So we've got about half an hour, give or take, of Tess getting us all up to the same level of understanding about what actually happened. And then we're going to have a panel discussion and some Q&A for the remainder of the session. And we've got Mark Anderson and Ian Thomas who are going to come and join us in the panel. So that's the rough shape of things. So Tess is one of a whole little ecosystem of lawyers around a legal case. I wrote it down. So I have my own in-house counsel who I work with on a day-to-day basis who was involved in this. I've got university lawyers in the central university who were aware and needing to be kept informed behind the scenes. We've got Powell Gilbert, whom I'll introduce to you and where Tess is from. And then we've got barristers, who are the people who stand up in the court and make the arguments to the judge. So there's layer upon layer of lawyers. Slightly more lawyers in a university context maybe than you have if you're in a private company doing this. So just to introduce Tess, she's a partner at Powell Gilbert, which is a specialist IP law firm. Tess acts for life science companies in commercial disputes and negotiations. She litigates in the High Court, the Court of Appeal and the Supreme Court. Also, interestingly, she started out as a doctor and did several years in hospital medicine before turning to IP law. And Tess and her colleagues advised OUI throughout the whole of the litigation process. So she's been our instructing solicitor that has engaged the barristers and told them the shape of the case that we want to do. Also, from my point of view, and very importantly, she made it fun, because it's high stakes, it can be quite stressful. It could have been those things and really onerous, but with Powell Gilbert on our side, it was fun as well. So I'm really grateful for that. So Tess, I'm delighted to welcome you to the stage.
Well, thanks very much, Murray, for that very kind introduction. I don't think anyone's ever described litigation as fun before, so that one might have to go on the website. I'm going to try and keep this as painless as possible in terms of laying out the law and so on, but I really am very happy to do an interactive session, so if there's things you don't understand or points you want to ask, please just do stick your hand up and I can try and address them as we go along. Because I mean, I have to say this is a relatively complicated case because it involves issues not just of patent law, which is like my bread and butter really, but also consumer law, which doesn't get raised very often in the patents court, and which is why we had a barrister team of two. So we had an IP barrister and also a barrister who specialises in consumer law to deal with those aspects of the case. Perfect. So just to give you a little bit of factual background. So obviously the case involved Oxford University Innovation, which, as you'll all know, is the tech transfer office of the University of Oxford, and actually started out as the claimant in the action. The university got joined as what's called a third party because of the defence raised by ONI and the consumer law issues. Oxford NanoImaging was the defendant, so it's a university spin-out that was sort of created to commercialise this product called the NanoImager, which itself is a desktop super-resolution microscope. And these two chaps, the older one on the left in the blue shirt, that's Professor Kapanides, so he's a professor of biological physics, at the university's Department of Physics, and was one of the inventors on the patents that we were fighting about. And the other chap is Bo Jing. He's currently a fellow at ONI, but he was previously the CEO and the CTO. He started out in Professor Kapanides' lab in 2013 as an intern, and then he started a DPhil at the university relatively shortly thereafter. He worked on the project that resulted in the NanoImager, and is also an inventor of the patents that are in dispute. He's famously described as low maintenance, which the judge self-described, I should say, which the judge commented on in the judgment, and I think everyone can probably form their own view given where we are now. So this is a long time coming, I suppose, is another thing to say. So ONI was spun out in 2016, and then I think, in the usual way, there's a license between OUI and ONI for the IP that was relevant to the project. ONI stopped paying royalties under that license in February 2019, and then later that year, OUI started like a vanilla debt claim in the county court just for unpaid royalties. And in return, they got quite a complicated and involved defence about ownership of the IP and whether the licence was in fact void, which the county court took one look at and kind of threw its hands up in horror. And the case was very rapidly then transferred to the Specialist Patents Court in London. Sorry. I'm clicking through my slides, but not yours. So the key issues in dispute, basically, the case eventually sort of split out into these two time periods. So there was a question about what happened during his internship and where the inventions that were made in that time, whether they had correctly vested in OUI or the university and subsequently OUI. And then there was a second part, the DPhil period, after he started his DPhil. And the question there was all founded in consumer law. So there's two issues that came up there, really. One was Bo Jing a consumer, so that he'd fall within the ambit of this the consumer legislation that's there to protect consumers. And this comes from European Union law. So the originally, which is implemented in the UK as the UTCCRs, rolls off the tongue. And then, assuming he was a consumer, then the subsequent question is whether the terms were in fact unfair within the meaning of that legislation. So these are the terms that would operate normally to transfer ownership of the IP from the student or the DPhil student to the university and then subsequently to OUI. I mean, initially, when the defence came back from ONI, there were a few other issues on there. So one of them was the patents at issue named Bo Jing, but also Professor Kapanides, and also another individual, Dr. Crawford, who'd also worked on the project as inventors. And obviously to get home on their entitlement point, because there was no dispute that if Professor Kapanides and Dr. Crawford were rightly named as inventors, at least part of the inventions would have belonged to OUI and the university. So there was a whole subsidiary question actually as to whether Bo Jing was the sole inventor and the other inventors shouldn't have been put on the patents. And they obviously were also made the point that during his internship period he was an employee of the university rather than enjoying any other sort of legal status. Now, for reasons of pragmatism, we and OUI decided that we wouldn't contest these points officially, not least because the question of inventorship is extremely complicated, time-consuming and expensive to resolve. So we took the view that we were quite happy to have the fight on the assumption that he was the sole inventor. So you can do that in English proceedings. You can basically say to the court, you know, for these proceedings, you can go ahead on this assumption. We're not saying it's correct, but you can make your findings on that basis. So we did that with the inventorship issue. So the case went ahead on the basis that in fact Bo Jing was the sole inventor, and we also did it on the employee issue. Again, for sort of tactical reasons. So we said to the court, we're quite happy for you to decide the internship bit of the case on the assumption that he was an employee, and we won't dispute that allegation for this claim. So the first bit, in terms of the internship period, I'm just going to give you a bit of a timeline so you can kind of get a picture of what happened. So Bo Jing actually joined a project that had been going on in Professor Caponidi's lab for quite a long time. So in November 2010, they got some funding from various sources to start this thing called the E. coli project. So what they were trying to do basically was, and there's probably people in this room that know a lot more about the technology than I do, but what they wanted to do was, it was like a biosensing project. So they wanted an assay to detect a pathogen, and then a single molecule fluorescence microscope to use to detect that pathogen. And at the time, these devices, they existed, but they were massive and extremely expensive. I mean, in the order of hundreds of thousands of dollars. So the plan under this project was to basically develop the assay and develop a compact microscope that could read it, so you could use it properly, like in a clinical setting, which should fit on a bench top. And once the money for this came through, two individuals in the Caponidis lab, so Rob Crawford, Dr. Crawford, who was mainly in charge of the bioassay, and a chap called Ludovic Larest started working on the project. And Ludo was basically doing the microscopy, and Rob was doing the assay. And by March 2012, so relatively quickly, they'd come up with this thing they called the small setup. So actually they'd done a lot of work, because this thing was 60 by 60. Already, so it was already a lot smaller, and they made pretty good strides. Unfortunately for Professor Caponidis, who was responsible for the project, in September of that same year, Ludo left the university. So they didn't, and then Rob took over on the microscopy, but it wasn't really his area of expertise. He was much more sort of wet lab guy, I guess. So that area of the work slowed down. And then, like manna from heaven, Professor Caponidis got an email out of the blue from this chap, Bo Jing, who wanted to come over to the UK because his girlfriend apparently was moving over here, and he had significant experience in this area, and he wanted to explore the possibility of doing a DPhil. In his email, he stressed his microscopy experience and what he could bring to the project, and subsequently there were 2 visits to the lab, and Professor Caponidis raised the possibility of him doing this internship, basically, before he started his DPhil, so he could come in and start working on the project, as soon as possible, while he was waiting to start. And that was all agreed. So in February, Bo started his internship in the lab, and as part of that, he signed sort of standard university papers, one of which included this, the standard university clauses about accepting that the relevant terms, including the IP terms, applied to him, and also that the university, therefore, would be entitled to the ownership of any intellectual property that he produced during the course of his DPhil. It's no dispute that he's an extremely bright guy. So he arrived at the university, and about a month later, he completely dismantled this small setup, the 60 by 60, and rebuilt it to his own design. And then about the following month, there was a meeting between the people working on the project and the DSTL who were funding it. Oops, sorry, apologies. And he basically presented this upgraded prototype at this meeting, and everyone was very impressed. And Professor Caponidis asked him to continue working on the project and take it forward. And it was, in fact, after that meeting that he came up with the invention that was protected by the first patent filing that OUI made. And then he basically carried on working on the project. until July 2013. And as I said, it's during this time that he came up with the specific invention that was then covered by the first patent family. So from a legal point of view, this is the exciting bit. There we have the Patents Act in the UK, and as part of that, there's basically, and you can't contract out of this. So whatever you put in your contracts of employment, this is going to apply unless your contract is more favourable. You're allowed to be nicer, but you can't give people less than what's provided for in the statute. So under this section 39, if you're an employee, any invention you make, basically during the course of your employment, is going to belong to your employer. And then one of the questions is it in the course of your employment? And under the Act, it is. If it's made in the course of your normal duties, or in duties that have been specifically assigned to you, and the circumstances are such that an invention might reasonably be expected to result. Note that it's an invention, so it doesn't have to be the invention. So it's pretty broad, and there's a second bit which wasn't really relevant in this case, where if you have a special duty to sort of further the interests of a company, then that's another situation where an invention you make will vest in your employer, and for that to apply, you're a director or you're heavily involved or something, that probably doesn't bite if you're just a run-of-the-mill employee. You can probably infer from the timeline that although there was actually quite a lot of heat and light about this and why he came to Oxford and what he was supposed to be working on, actually before trial, ONI had to concede that at that meeting in April 2013 with the DSTL, he had been, whatever else had happened and whatever his normal duties were, had been specifically asked by Professor Kaponides to work on the microscope. So the real fight at trial was about this question about whether an invention could reasonably have been expected to result from that work. And this is what ONI said. They said it wasn't reasonable for various reasons. Actually, just taking a step back on this question about can an invention reasonably be expected to result? Under UK law, the current position is that generally, if you're employed to innovate in a very general sense, then the test is satisfied. So it's quite a low threshold. So you'd think it's a bit of a slam dunk in that he's working in a research lab on a research project. He's already, demonstrated he's pretty good at this, and he's been asked to carry it on. But nevertheless, they ran this case that it wasn't reasonable to expect an invention to result because of his low status at the university, because he was very young and he didn't have a lot of qualifications and experience. He wasn't paid a huge amount. He said that the inventions didn't relate to the biosensing project he was asked to carry out. So his evidence was that he was supposed to be working on the assay side of the project rather than the microscope. He said he didn't get any support or direction as to what he was supposed to be doing, and his contract was quite casual in nature. So for all of those reasons, ONI said Section 39 didn't bite, and he should be solely entitled to the stuff he came up with during his internship. Now, this is an ambitious case to run. And we said, this nonsense. He was hired for the express purpose of carrying out work on the small setup. He was paid to carry out that task, albeit at a modest salary, but then he was subject to the IP terms, which, did provide for a significant upside if he did make an invention, potentially. He demonstrated that he was very good at what he was doing, and then he was specifically asked to carry on with it. And in the circumstances, it would be remarkable if an invention couldn't, in the broad sense required by the Act, couldn't have been expected to result from it. So pleasingly, the judge... Oh, yeah, please.
Sorry, but was the interment agreement, did that constitute a contract of employment for the purposes of the Act?
So their case, so ONI put forward a positive case that it did, and he was thus an employee. And our view was that if you want to have a fight under Section 39, we're perfectly happy to be on that, to be there. So we will not dispute it. But we in no way accepted that for anything outside of the purposes of the litigation that his contract rendered him formally an employee. If that makes sense. So pleasingly, the judge was wholly on board with our arguments on this. So he basically said, he made a whole load of findings. Basically, when Bo arrived, his duties included development of the small setup. So he thought the contemporary documents and Professor Caponidi's evidence was clear on that. He said from at least that DSTL meeting, he was employed to innovate in the general sense, in that he was being specifically asked to drive forward the development of this microscope. The whole reason he was asked to do an internship was because of his attributes, which made it particularly likely that he would come up with an invention. By that meeting, as I said, he'd already demonstrated he was really good at it, and he was specifically asked to carry on. The judge actually said that none of the factors raised by ONI were relevant to the analysis under Section 39, which is effectively, following the law as it currently stands, as set out by the Court of Appeal, and/or he said they're just not supported by the facts. And I think he had a lot of sympathy for Oxford's position. So we basically said, look, if you're coming in to work on a project that's been ongoing already for a few years, you're building significantly on the work other people have done, it would be very surprising in all the circumstances if you could come in and take all the benefits of that, and exclude other people who'd been working on it and the university. So far, so straightforward. So then we move on to the unfair contract terms question and these points about whether he was a consumer and whether the terms were unfair. So again, just a bit of a timeline. So that picture, that was in happier times when Bojing and Professor Caponides received the BBSRC Innovator of the Year Award for developing the NanoImager. So in terms of the DPhil, in fact, he put in his DPhil application a long time before he started, well, probably not a long time, but actually before he even started working in the Caponides lab. So in January 2013, he put in the DPhil application. Professor Caponides was his supervisor, and he said that his research was going to be in effectively single molecule fluorescence microscopy and assays. He was made a formal offer in February 2013, and that offer letter incorporated the university statutes and regulations, including on intellectual property. He signed that letter, he signed his formal contract in August 2013, again, which incorporated the university statutes and regulations. And it's worth noting here that by the time he signed that contract, he'd already done his internship, he'd come up with the internship invention, and they'd started the process of applying for patent protection and so on with OUI, so he'd had to fill out all the forms, and he knew exactly what was going on in terms of ownership of the IP of the project as it had been to date. And then in October 2013, he formally started his DPhil. And he carried on working on the NanoImager. He developed a further prototype. They started talking about a spin-out with OUI in 2014. The application for the second patent family, so the second patent family, broadly speaking, protects inventions he made in his DPhil period. And then, this was quite a long and drawn-out process, but by the end of June 2016, it was basically agreed that OUI would take 50% of the equity in Oxford NanoImaging, and Professor Caponides and Bo would share the remaining 50%. The company was then incorporated, and Bo was appointed as the CEO. And then in April of that year, the license agreement between OUI and ONI was signed. So, on to the law. So their case was that effectively the terms of the university's IP provisions, as we called them, so the statutes and regulations, were unfair within the meaning of the Unfair Terms and Consumer Contracts regulations. And, as such, then they were void and did not correctly operate to transfer title to the inventions to the university and then OUI. And then taking it a step further, that means the contract, the license, is also void because it was entered into on the basis of a mutual mistake as to ownership of the IP. So these regulations apply to contracts between a consumer and a seller or a supplier. We didn't dispute that the university was a seller or supplier within the meaning of the legislation, at least in part because there's CJEU jurisprudence which proceeds on that basis. So it seemed sensible not to resist that. So the issues really were, whether he was a consumer, and if he was, whether the terms were unfair. Now, a consumer is the line between consumer and non-consumer, I think, is difficult to draw, and there's a whole line of cases that attempt to grapple with it. But effectively, the regulations, as it says here, define a consumer as somebody who's acting for purposes which are outside their trade, business, or profession. And I think you can see, even looking at that test, that there's going to be cases where it's really obvious, either at one end or the other, and then there's going to be cases where it's quite difficult. And a lot of the case law focuses on where people enter into contracts for like dual purposes. So it's like part professional, part personal, or whether people are truly consumers. There's lots of case law involving extremely high net worth individuals who are, trading financial instruments and so on, and a dispute about whether in fact they're consumers or because of their nature they're actually acting for business purposes. So it can be quite fact specific. And once you've established you're a consumer, to fall within the ambit of the legislation, effectively, you've got to say that you've got to show there's a contractual term which hasn't been individually negotiated. And again, obviously ours wasn't, so this wasn't an issue for us. And then it's going to be unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights, basically, to the detriment of the consumer. And the whole point behind this is is obviously consumer protection. So where you are in the business of presenting standard terms to people, you can't just sort of take advantage of that by imposing penalties or various other unfair terms on them. So there was an interesting question about students as consumers, and I should probably say here that we weren't running a case that students were not consumers, and we weren't running a case that DPhil students were not consumers. We were running a case that Beijing was not a consumer. So there's obviously a bit of nuance here. The judge spends quite a lot of time looking at this, and he comes to the conclusion that in general, DPhil students are normally entitled to be treated as consumers, and undergraduates even more so. And he thought it didn't really matter for this purpose whether they're undertaking their DPhil or whatever postgraduate qualification it is, for the purposes, with a view to career enhancement or otherwise. And I think the reason he came out here is because he wasn't very attracted by the idea that you would draw a distinction between, I suppose this is an undergraduate example, but somebody who comes to university to do medicine, where they're clearly overwhelmingly likely to be using that degree for their trade, business or profession, and, for instance, an arts graduate at the same university. Like, why should one of them be protected by the consumer legislation and one not? And then looking at Beijing specifically, he thought that the factors were not such to take him out of the general approach that he too should be a consumer. Now, he did. I think he found this quite finely balanced, but in the end, he came down on the side of deciding that he was a consumer. And in this context, he said it was kind of irrelevant that he'd previously worked at another university and that he probably was undertaking his DPhil for sort of, his future career prospects. It doesn't matter about who contacted who first in terms of him being a consumer. That's irrelevant. The fact that he was doing stuff that was basically similar to an employee was also not decisive, although he thought it was relevant to the question of fairness. The interesting thing about some of this stuff is, although the legislation and the way the case was argued splits it up between consumer yay or nay, and then the fairness of the terms, quite a lot of these points kind of bleed over from the consumer issue to the other, and that's very much the way we ran the case. Was Beijing was not a consumer for all of these reasons, but even if as a matter of principle, we're wrong on that. He's only just a consumer, and all of the points that we're discussing about which side of the line he falls then should play into this assessment of the balance between the parties and the fairness of the university's terms. So on the IP terms themselves and their fairness, O&I said they were unfair because they involve a sort of blanket uniform approach and will apply in all circumstances, and that's too broad and inappropriate. They said the terms were more favourable to the university than comparable provisions applied at other universities. They said which is kind of linked to their blanket approach point, that no matter the circumstances, they produce the same results in terms of ownership and so on, regardless of the underlying factual matrix. They are unfair because a student is kind of precluded from taking legal action or exercising legal rights concerning the IP issues, and they do not sufficiently protect the interests of more junior members of the team. They thought they were unduly weighted towards senior academics and towards the university. And our position was that the terms were fair, and in fact had clearly operated fairly with respect to Beijing. And again, it was quite a jury point, but we did say that it's hard to sit in court and think that someone's treated unfairly when they have a sizable chunk of equity in a successful spin out. They're the CEO, and they're getting a significant royalty income, from that project. We said, in fact, the terms are in line with those that are applied at other institutions. They're more favourable than would have been the case if he'd been an employee. And, the university had done their best considering carefully the terms and balancing the issues of the various stakeholders. And we had, as is the case in UK proceedings, we had discovery and disclosure on this. So the court had various minutes of the university's intellectual property advisory group to consider. We had an excellent witness who appeared and explained how the university deals with all of these things. So I thought it'd be quite helpful just to talk. Oh, sorry, go ahead.
Hold on. Sorry.
Hello, I'm Anna Aguilar from TENU. How was Beijing funded, and does that matter?
Yeah, good question. So he did receive some funding from the Caponides lab, but the judge thought that was irrelevant. Again, I think because he was troubled by the fact that you would get a different answer in terms of consumer depending on how somebody was funded. So you could have two people working side by side, and one who'd received some funding would be a consumer. Receive funding would not be a consumer and therefore not protected, whereas the other one would be a consumer would be a consumer and would be protected by the legislation. So I think part of what the judge struggled with, and by struggled I don't mean that he didn't understand it. I mean he to come up with a sort of principled reason. I think he wanted to draw a bright line, and what we were urging him to do was effectively say, well, this is all shades of grey and it needs to be considered on an individual basis. And I think he wasn't super attracted to that as an outcome. So in the end, he sort of came down on the side of actually pretty much unless you can show something relatively out of the ordinary, they should all be consumers. And another reason he didn't really like it as an approach, he wasn't attracted to it as an approach, because obviously once you have to get into a sort of case-by-case analysis of this, it's evidentially quite heavy, potentially. Like, you've got to look into what somebody's been doing, where they've come from, and start examining that fact pattern, which he just thought was maybe not a particularly practical approach, and difficult for you guys and people like you who are trying to apply this in practice. Because if you've got some people here, some people there, are you supposed to, how are you supposed to decide which of your students are consumers and which aren't?
A couple of questions really. Is that Beijing, as an inventor, was he still entitled to receive a share of the royalties going back to Oxford, or had he waived that? And I noticed that DSTL are there as a funder. Was that under DEFCON 705, or did they have a view, or were they contacted?
So first I've heard of DEFCON 75, but I like it.
I'm just pretending I know what to talk about.
Yeah. So
DEFCON 75
So this was not an issue for us. So my understanding is whatever the arrangement between DSTL and the university was, that DSTL did not have an interest in the invention. And as to your second question, yes, Bo was entitled to royalties, and we'll cut. Oh yeah. So in fact, it was a slightly odd case because sorry, this is just by way of aside. So when you put in witness statements in the UK court, you usually will say if someone has a financial interest in the outcome of the litigation. And Professor Caponides, who gave evidence for us, and Rob Crawford obviously had a financial interest, because if the university and AUI won the case, then they would get payment of the back royalties that ONI hadn't been paying. So we obviously put that in their witness statement. But obviously, in fact, Bo as well, although his case was that he shouldn't be getting them, if he lost the case, he was entitled to, big chunk of money. So yeah, it was a slightly odd situation. So this is part of the university statutes as they were in 2013, and they have actually changed since that date. But this is what applied when the period we were talking about, and the main bone of contention was this paragraph 5 1b, so that the university would claim ownership of all IP devised, made, or created by student members in the course of or incidentally to their studies. Now, the judge was a bit troubled by incidentally to their studies, which he thought was, on one construction, was too broad. But in the end, he decided that paragraph 5 did not create a significant imbalance between the parties, because while the terms could operate in a way that would entitle Oxford to make a claim very, very broadly, so to stuff that students had just happened to do while they were at the university on their Todd, so to speak, which could be inappropriate. There was no evidence that Oxford had ever done this, or that the university had thought it was appropriate to make such a claim. And in fact, there was evidence showing the exact opposite, that the university had never intended to do that and had never sought to apply the clause in that way. And he also thought, as a basic legal principle, we have this contractual construction rule in English law called contra preferentum. So the contractual term is generally construed in favour of the person against whom it is sought to be enforced. So he also took the view that you could construe this clause broadly and say, oh, incidentally to their studies is terrible, it's really, really wide. But equally, you could take the view that if in fact there was a dispute about this clause, it would be construed in favour of the student. So it would be construed narrowly, so that incidental to would be, as a direct result of their studies at the university, rather than something they just happened to do while they were a student there. Interestingly, one analysis sorry, please.
It's an interesting point, this about ownership of student IP, because whereas you stressed before that Oxford was in line with other comparable universities, in this case, Oxford was out of line with other comparable universities. And of course, there's a whole question of whereas employees are paid, students are paying. And so it's interesting that the ownership by the university of student IP wasn't sort of challenged.
Well, it was. It obviously was challenged. I think in terms of his comparison with the terms of other universities, it is an assessment in the round. So, we'll come on to the royalty sharing and how Oxford deals with equity splits, which were very much in line, if not more favourable, with what other universities were doing.
Hi, does your definition of student in this case, I'm Paul Dillon from the University of Limerick in Ireland. We'd have similar, I'm actually coming out of a patent revocation case, so this is some of the interesting aspects of this case. But your definition of student in this case is applying to all students, including undergraduates?
Yes.
So there's pretty much a case precedent here for most universities. Would that be your conclusion?
Yeah, so I think this is pretty clear that students are to be regarded as consumers.
That's a pretty significant development.
Yes, although I would note that there was some OFT guidance in a while ago, I think 2015, where it was sort of proceeded on the assumption that they should be regarded as consumers. So I don't think it was wholly surprising in terms of, at least in terms of undergraduate. I think the postgraduate point is a bit trickier. Sorry, Mari's telling me that I need to
so
get
just a related question on the undergraduate though. when you have students enrolled, do you, like if you don't re-enroll them each year, you could have students enrolled before they're 18, and I'm assuming you have similar contract law here, you can't have a contract with a minor. Would that have come into play?
Luckily, it did not come into play here.
Okay.
Despite Bo's protestations that he was very young and inexperienced, I think he was like 29 or something by the time this was all happening. So this is just coming on. Sorry, I'm going to speed up a little bit, but I'm very happy to answer questions, after the session and over lunch. So this is the royalty clause, and you'll see, I think in line with most other universities, it's very favourable to the inventors before you reach a certain threshold. And, the evidence was, I think, the vast majority of Oxford University spin-outs end up making more money. They never get beyond that first threshold, so that the inventors are taking the lion's share. And then this dispute resolution thing that they were complaining about was basically because there was a mechanism in there if people were unhappy to have a sort of for the vice chancellor to adjudicate, and that's why they said that it was sort of curtailing their legal rights. And then just student inventors generally. So the judge did actually do a bit of a trawl through comparable universities. So I say comparable, but the other side put in evidence, I think, of the IP policies of the top 20 universities as assessed by the Times Educational Supplement and stuff. And he did quite a thorough analysis. And he basically comes out that this is what university policies broadly provide. So that if the student's working in collaboration with employees on funded projects, is carrying on work that other people have done, using university equipment or facilities, that's all fair game. It's perfectly normal for the university to claim ownership there. And also he found that in general, across the board, that the students are treated in the same way as employees, in that they get this, they get to share in the royalty income, and they get to share in the equity of any spin-out company. And just in terms of this dispute resolution and the one-size-fits-all approach, he didn't think any of that was unfair at all, because he said there's no harm in having a blanket policy. Sometimes it will be less favourable to the inventor, sometimes it will be more favourable. These things have to be looked at in the round. And just because the vice chancellor having the sort of final say-so is just a pragmatic way to deal with disputes. It's not problematic. And then this question of good faith, I mean, at the end of the day, and I think this is a key message probably for everyone, is that he recognised that when in Oxford's case specifically, and then in university's case generally, everyone has a lot of interest to balance in terms of stakeholders and what's the appropriate, what are you trying to do? It may be that you want to really foster innovation and get as many spin-outs as humanly possible, but which was what ONI's position was, but it's entirely legitimate for the university actually, to think, well, really we don't want to be encouraging all our academics to, commercialise their inventions and then run off and join the private sector. We've got lots of other things we need to worry about. We've got charitable aims. We've got, you'll know way more about this than I do, but you've got your research frameworks and your impacts and so on to consider, and how an individual institution comes down to balancing those various factors and perhaps rewarding inventors whilst retaining benefits for the university more broadly is up to them. So there's a lot of leeway there. And again, we were helped by our evidence because we had a wealth of documentation and evidence basically showing that the university had considered these issues, really, really carefully, with student input, with input from various departments and so on. So, I mean, there was nothing there for the judge to make a finding that this was done in anything other than good faith. So, that's where we came out, which was great. Just by way of update, ONI did seek permission to appeal, and they have been granted permission to appeal, at least in part, I think, because the judgment took forever to come down, which was quite irritating. But also because they said this is an issue of general public importance, which the Court of Appeal should have a look at. So that appeal is scheduled for January 2024, and I think we would expect to get judgment sort of March, April-ish. So this isn't the final word on the issue, but I think in the interim, it's a really interesting decision. Thank you.
Thank So as well as Tess, who thank you so much for giving us that overview, Tess. I know all the details of this. We've spent such a long time with it, but it's still really interesting to see it laid out in that way. So we've got Ian Thomas, who I think you will all know, is head of Cambridge Enterprises Life Science team, has a long list of incredible deals to his name, and is chair of Practice Oral. And then we've got Mark Anderson at the far side, and Mark is a solicitor in private practice. He established Anderson Law in 1994. He advises lots of universities and public bodies. He's an honorary professor at UCL. He does lots of training. But the reason why he's here today specifically is he's an author of books and the IP Drafts blog, and has blogged extensively on this case, and has received many views of his blogs on this. So Mark brings a different context. So the way that we've, I do have some questions that we can work through if we don't have questions from the floor, and there's a few topics that we would like to cover. But are there questions from the audience, first of all? Laura, please.
Thank you. So Laura Donnelly from Cambridge Enterprise. It's fascinating to hear the whole story. Thank you for that. But I'm wondering, what do you think the consequences of this would have been if the judgment had gone the other way?
So, are you going to go first, Ian? There's a sort of a question for Tess about the specifics of this, and then for Mark and Ian more generally, I think.
Well, I mean, I suppose again, there's two bits. There's the Section 39 bit, and I mean that really would have been overturning established jurisprudence in that area. So that would have been a big change. On the consumer stuff, I mean, well, it obviously there would have been significant ramifications. I mean, once your students are consumers, if the High Court has said that these terms are unfair, not only would they have been unfair as against Bow, but they would have been unfair as against any other student inventor for, a relatively long period of time. And I have not done a comprehensive survey of the IP terms and conditions of every academic institution in the UK, but I can imagine it could have been problematic much more broadly than just Oxford.
Yes, as most of us know, we have huge numbers of students, PhD students, or occasionally undergraduates inventing, and it would have profoundly changed that balance of ownership, and it would have changed how we as universities could operate and trade that, to the point that you could have seen a situation where we'd have been significantly cut off at the knees in managing lots of IP. And then if you look at that in the context of can people like Bow and others go off and commercialise successfully on their own? Yes, there are great examples of that, but the real evidence shows that most people have struggled commercialising without significant help and support from their universities. But if the universities don't have that access to the IP in quite the way they have done before, that makes that much much harder to provide. And I think this has just thrown a huge load of grit in that wheel, those cogs across our system. And I think it would have been hugely detrimental to the greater output that our entire community produce. I'm sure you'd find examples both ways where it would have got slightly better, but actually it would have been profoundly slowing of our innovation ecosystem and outputs from universities. It would have been a real disaster.
Thank you. Well, I agree with everything that's been said so far. I suppose I come back to the two kind of campaigns that were mentioned in the case. There's the campaign by students saying that universities are unfair to them in their IP policy terms, and there's also the campaign by investors saying that universities are unfair in the shareholdings that they expect in spin-outs. And I guess it would have just been fuel to both of those campaigns if it had gone the other way, and that would have had some pretty major consequences. That's not to say that these campaigns, particularly the one by shareholders, isn't quite strong anyway, but it would have been even stronger, I think, if the decision had gone the other way.
So I suppose just one final point on that. I mean, at the heart of ONI's case was a kind of unspoken assumption that if Bow or Mr. J himself had owned all the IP, everything would have gone much better. But I mean, if he had made it in his garage, he didn't have the network, he didn't have the expertise, he didn't have the cash to pay a patent attorney. So, I think also the court was relatively mindful that counterfactual wasn't realistic.
And locally, specifically for OUI, Had they prevailed on all of those points, it would have had the result in overturning the licence, because the licence would have been void for mistake, as ONI contended. So that would have meant that we would have had to put ONI back into the position that they would have been had none of this happened, right? So we would have had to repay all of the monies already paid and, by the way, distributed under the licence. So it would have been quite painful, quite apart from the broader things. Question from David.
I just wondered who were the solicitors on the other side and who was paying them?
So there's solicitors on the other side that were originally Blake Morgan, and then the partner moved to Clyde & Co, so that was then Clyde & Co. They were being paid by ONI, as far as we are aware.
So this one and then Jackie. So one here first.
Could you comment on the materiality of the defill contract here? Like, was it completely, sidestepped? Like, could it be relevant if you had lost the case? Or, in other words, we would use that in our institution as a basis, as well as our policy. So, the policy is like the buttress, but the defill contract is the.
Yeah, so the defill contract basically incorporated the policies. So the policies were in effect a term of the defill contract, even though they were in a separate document. So
in our defill contract, as well as a reference to the policy. But did that get looked at in this case, or was it completely sidestepped? It was just the policy and fairness of the policy.
Yeah, there was no dispute that if the policy was fair, then the intellectual property would have correctly vested in the university and hence OUI, so that wasn't a factor.
Yeah. Thank you. And then there's another question at the back, Jackie.
I've just got a question on the appeal, because we've just heard that if this gets overturned, there's huge ramifications for the sector. Are they appealing every point? Or, I'm not quite sure how that process works, or whether you can comment on that.
Yeah, of course. Sorry, that's a good question. So they're appealing every point. So they're appealing on Section 39 of the Patents Act. They're appealing. Apologies, and they're appealing on the fairness of the terms. They're obviously not appealing on the consumer point because they won on that.
Good question. So there's a gentleman, same row as Jackie.
Yeah, Bruce Etherington from ESRC. But I think one of the questions for me is, although at the next question, the university sector has won the case, are there things that we should still be doing better as a result? So are there ways we could explain to students the IP process, so when they've got those contracts, they've got more information about what it actually means? We're going to put 50k into patents, we can do this, this, and this, therefore, that's why you're signing it away. So what lessons have we got, even though currently we've won?
That's a really good question. I mean, practically speaking, I think everybody should be looking at their IP terms and conditions by reference to the judge's comments in this case to make sure that they're falling on the right line. And two, you're 100% right that one of the issues is that students are just presented with a contract which refers to a whole load of terms and conditions which are, they're not difficult to find, but how many students actually go and look for them? So I think it would be prudent as well, yes, to be specifically drawing some of these points to their attention, particularly in the case of postgraduates who are working in research labs where they're likely to come up with inventions.
So apart from the fact that we should be looking at these things, but possibly waiting to the appeal result, because that could throw things in the other direction, of course. And I think we should be generally educating our students when we can. I think my observation is that they don't necessarily absorb it as in a general concept. But when you do encounter people, we found it being at the point when commercialization may be happening, they may have made an invention and all that sort of stuff. We have found that's really the point of engagement. We found that hugely valuable to take people through all these points. Be generous with your time and recognize that what may seem very simple to all of us in this room is actually pretty bamboozling when you first read it. And I referenced the story at dinner last night about insurance contracts that we all sign and probably never fully understand. It's probably not. It would be stupid to assume that even our simple IP policies are really trivial. They're not. They're complicated things for people who've never encountered it before. So it's about acting in good faith and being reasonable.
There was a whole thicket of questions. I'm sorry, I didn't spot whose hand was first, so bear with us.
Well, I've got the mic, so I guess it's me.
Well, shall I finish?
Oh, sorry, beg your pardon, Mark's got a comment first.
Just finishing off on the previous comments, I think yes, the IP policy is probably one of the main areas to look at, and it's a multitude of things. It's as happened in Oxford's case, Oxford then revised the IP policy to bring it in line with what actually happened, rather than the rather protective wording that it had previously. So that's one aspect of the policy. There's it's gone out of my head. The revenue sharing arrangements, and particularly the shareholding arrangements, look at those and see whether they make sense. Make sure you actually get an assignment rather than just rely on any idea that, oh, well, it must be in the course of your employment or in the course of your duties, and therefore we will automatically assume that the IP belongs to the university. I know of some universities who take that view, and I think that's a risky approach. I think it'd be better to be specific. Think about whether, one of the things that happened in this case was that the professor arranged for Mr. Jing to be an intern, but I'm not familiar with the inside story here, but the best, the closest internship category on Oxford's website seemed to be one where it was, I think it's for up to 3 months. It was guaranteeing a minimum wage, and it was providing experience of industry. And the professor used that category when it didn't actually meet that category, because £6,000 might have been the minimum wage for 3 months, but it certainly wasn't for 7 months. It wasn't work experience. It was actually doing a job as a product designer. That's the bit that troubles me, that I know that professors work the system to try and make things happen to get on with, but maybe you need to be thinking about whether internships are actually a sensible way of engaging effectively students. There's so many things that could be looked at, but those are a few anyway.
And so just on that point, ONI agreed that he was an employee during the internship, so we didn't have a detailed discussion about that during the course of the case.
Okay.
So there was a question at the back over here.
Yeah. This question is probably easier to represent in a slide in a 2x2 matrix. But it's essentially, what are the ramifications for, and what advice would you give to, A, students undertaking internships, and B, companies who are offering internships in the light of this case?
Good question.
So this is... Can you just say the last bit again? I didn't fully...
Yeah. I'll give the whole thing. So you've got two questions and two categories to whom they apply. One question is, what are the ramifications for? And the second part is, what advice would you give to, A, students undertaking internships, and B, companies who are offering internship placements to students?
Oh, internship. I thought you said term sheets.
No.
Right. So I think I'll have a go at this. I don't do this kind of thing regularly. I think when you start offering students internships, and I'm not talking about any of the employment conditions, just around the IP, I think we should be very clear about what the consequences of those IP terms are to them, and explain that and take that through some sort of case studies or theoretical examples. I think that's the first thing you should do. I think you should also then be thinking about, when you use an intern, and use, I don't particularly like that word, but when they are in your laboratory, how they're deployed. You may want to think about that rather more carefully. I mean, you can't stop people inventing things, but most people are taking an internship to get some experience, to see if something's right for them or whatever. It may be more. You may be want to be more careful about how you use them in that. So those are my first 2 points. But if others want to add to that.
I mean, on your second category of person, is that an internship at a company? So, for instance, at ONI or any other sort of commercial enterprise? Because I think there that enterprise probably wouldn't be a supplier within the purposes of the UTCCRs. So you wouldn't have this consumer dynamics. It would just be a sort of normal contract. So you just need to make sure that everything was covered there.
Good.
This is sorry.
Yeah,
This is something that somebody raised on my blog, IP Drafts, one of my articles about this case. And I think he's an in-house patent attorney at a company. And his view was that it was a risky business funding an intern at a university because of the risk that they would be own their own IP because they were consumers and any policy of the university might be unfair. So I guess we perhaps need to wait and see what the outcome of the appeal is before we know how big a risk that really is.
Sorry, one final point on that. Just that one category of people the judge thought might perhaps not be consumers are people who are, like for instance, a lot of IP lawyers do a postgraduate diploma in IP at the University of Oxford, and that's all paid for by the law firms and basically run, between them, and it's very much a professional qualification. So those sorts of people, might fall the other side of this trade, business, and profession line and actually be, not be consumers.
Good. I'm going to take one more question, then I'm going to seize control because I've got the microphone and move it in a slightly different direction. So one more, please.
Yeah, thank you very much. I'll try and explain that. So in terms on the legal kind of understanding, just to focus on the legal side, the an internship or PhD agreement is quite general. It has a student, and the research is quite general. It can go at all different directions. On the other side, and again on the legal kind of side of things, when companies operate and they need something to be delivered, this can be done, for example, under a service contract agreement where you list all the deliverables. So what I would like to understand is whether there is a conflict between the PhD agreement and an SLA in terms of again, the legal side of things, whether, for example, a PhD agreement could be structured in a way that there is a deliverables list attached to it, in the same way as a PhD would go through the deliverables and evaluation every year. I think there is that sort of evaluation going on annually and different goals agreed. So to make it more specific and actually allow both parties to work together on specific goals and at the same time, protect any other thing that is coming out of this list. These other things, where would those be captured and where under this type of legal agreement? I don't know if I've explained that clear, but happy
Yeah, thank you. Mark?
So I think this starts to sound like the conflict between a commercial company wanting to engage someone to provide technical services versus somebody doing a PhD or a DPhil. And if I'm acting for a university in that situation, I'd be trying to explain to the company that this is not a services agreement. You cannot expect specific outcomes. What you were doing is you were funding someone to do a PhD. And so I think there's a bit of a mismatch between commercial objectives and academic objectives in that kind of situation, which needs to be explained. And if in fact the company is just looking for an outsourced R&D service, well, a university studentship is not the route to be going down.
I mean, we should be remembering what a PhD is all about. A PhD is an intellectual training into the scientific method that happens to be in a certain domain because hopefully the student's interested. We'd always help that. And you're never expecting any deliverable for anyone beyond a thesis that explains what they went through, which can legitimately, it's always harder to write up, legitimately include high quantities of failure. In fact, and the hypothesis may not have worked, and all that sort of stuff. And I think that we should remember this is a training ground around the scientific method, and it's nothing to do with the deliverable beyond demonstrating what you did to your examiners, a very different class of deliverable.
I mean, just a final comment is in some ways as well, it might be counterproductive to try and introduce that structure into a DPhil contract because, you know, the DPhil will go where it will go. But as long as your IP terms are drafted, you know, in the way that we now have guidance on, anything the student does, you know, in relation to an established project, they're working with university personnel, et cetera, should legitimately fall within what the university can claim anyway.
Yes, thank you for that. And I kind of acknowledge at the beginning of the question that I understand that the PhD is quite a general, and as you've mentioned, a training exercise, and it can be very broad and go at all different directions. But maybe to make it a little bit more specific, so if somebody is like working on a kind of a physics project, but through the physics project can come a discovery on the biology side of things, would that still be, you know, all the focus is on the physics, but then the discovery can be like on a different field? Would that still be the case? That's
yeah, as long as they're still doing it, you know, in the course of their studies. I don't think it doesn't really matter if they're doing a DPhil in physics and they, you know, they actually come up with something, you know, they stumble across something else or whatever, as long as they're, you know, it's within the confines of what you can legitimately say is basically effectively part of their DPhil, or they're, you know, they're working with other people at the university.
Thank you. So I'm going to ask you a question now, because in this room we've got a whole manner of different sizes and shapes of institution, and I think you can probably surmise from the story that Tess has laid out quite how much nitty-gritty detail is entailed in piecing together what's happened and understanding where the key points are and constructing those arguments. But how many of you think that your institution would sue for infringement or pursue a debt claim to the extent of ending up in court in an IP dispute? Can I have a show of hands, please? I've got an Oxford person there putting their hand up. So,
Hold them high, they're few, so let's see the few hands.
Yeah.
Could I share a case study? I'm in this process at the moment.
Not until you've got a microphone. Yeah. So there was a flurry of hands, but not every hand in the room, and there was a few doing this sort of thing, ups and downs and ifs and buts and maybes, and that's a really good answer because it's always going to depend on your circumstances. Please.
Yeah, so I think today we're in a patent revocation case in the Irish court, and it arose out of a spin-out company who got into a joint venture with, you know, another individual, and they formed a JV company, and then essentially had a row, parted ways, and both parties continued to pursue a similar set of technologies. And in pre-COVID, there was some, what we call the shot across the bow letter. You know, we have this patent, we see you're doing this activity, please cease, you're the cease and desist. And then it kind of, there was a separate, because of the name of the company, there was a separate trademark infringement, so legitimately the company kind of folded, and the other party, the non-spin-out, formed a new business. And a second shot across the bow was issued late last year, and they countered with a revocation case. And we got dragged in as the patent owners because we've licensed the technology to the spin-out. And we don't have a high expectation. The spin-out's over at 10 years out. At 2011, we spun it out. From the university point of view, there was no commercial advantage for us to defend it. Interestingly, we couldn't get clarity from our insurers as to whether we were covered on the case. We finally got clarity 2 months into it when we said we weren't going to contest it. But we were faced with one of the interesting decisions, why I wanted to feed this back in, because it's all about context. And we had an argument that our spin-out was in breach of the license agreement by the performance clauses. It hadn't met them in terms of the diligence to proceed to justification. We had actually set some specific targets of revenue, investment, et cetera, that they'd failed to meet. And there's something I wanted to share out of this, because we had failed to police those, and that was a serious implication when the barrister was giving us a view of terminating the license as to whether by failing to enforce the performance clauses in our license agreement, had we sort of let them off the hook and therefore couldn't suddenly enforce them at a later stage. So we didn't have clarity that we could terminate the license with our spin-out and then give a license to the other party and get out of this mess, so to speak. And unless we were in 100% position clear, the university did not want to take a case against the spin-out. Young, female entrepreneur, PR savvy, very connected to the media, won tons of awards. You know, it's in the environmental energy space. It was very easy to see a PR disaster, you know, coming out. And so your reputation does come into play in that decision. Had we got 100%, I think we might have pursued that approach. But the risk of a second case against the spin-out with a PR mess on your own spin, and then the message to your own spin-out community is, you know, is the university got your back, or have they got a knife ready in their pocket? So yeah, it's a very interesting question for the community, and I think it's very hard to give a general answer to a general question because of specific circumstances. But for us, it was a very
unfair. I agree.
Yeah.
Good. So I'd like to talk about oh, is there someone at the back? Thank you.
Hi. I had a question. So a court case can be quite scary for a DPhil student who may has an idea. Can universities do something learning from this case that will not scare off postgraduates to form a company?
Well, it was in the hands of this particular ex-DPhil student to decide whether or not to proceed with the dispute. And I think I might just stop at that point.
Just curious, yeah.
Yeah, I mean, more generally, that like a lot of the university's IP terms provide for some sort of ADR provision if there's disagreement, and obviously there are ways of doing that out with the court procedure, even if you're not falling within the terms of your agreement. So you can mediate disputes, you can arbitrate them, there are various other avenues, some of which we attempted to try and resolve these things before you get to court.
Ian?
I think, always try and avoid getting to court, but I think it's about being very active in your management of circumstances. So this gentleman here talked about maybe they hadn't followed their diligence or followed up the diligence clauses and that. I think actively working with your spin-outs to see what they've done and holding them to account fairly. And this is all about being on the same side as them, but just checking in with them and getting your reporting clauses is very, very critical. And I think we've had a couple of cases which we have not gone this far, but where it's interesting where if you find you're getting yourself very well legally informed about what options may be, what the risks might be, and because we don't understand the law as well our learned colleagues do, and also how judges may see things. Becoming well informed also then helps you, not in an adversarial way, have some discussions with with your potential conflicting party in a way that can normally, if well handled, diffuse circumstances. And I would really counsel that is probably the best way to go.
I was going to, do you want to add a comment on that one? Anne?
Thank you.
Sorry.
Thanks. Anne Lane, UCL. I think we had a case quite a long time ago that I had to deal with where we were sued by one of our academics in a similar way to this, and it went to the High Court. And there was talk about us countersuing the academic, which we decided not to do. But then at the end, when we won, we did win. We waived we made a standard payment that the academic had to pay us, which was quite a small amount. So we could have gone for full legal costs and everything else, but we decided not to under the circumstances. So that's another way that you can. I mean, if the situation's gone that far, you can't really diffuse it, but you can make sure you're not really going to town.
I mean, we should maybe remember what we're trying to do here. We're trying to always make sure technology is going out there. We're not trying to win a commercial battle, but we also know that if we start to look like we can be rolled in commercial circumstances or versus, and it becomes versus at this point, our researchers, then that is setting us down a path that's going to make our future activities harder to do. So it's about taking a firm position, but not necessarily claiming all the points.
I might be appropriate. I've got the words here from the judge in the case on this point. So he says, "This is the first occasion on which OUI has brought proceedings against one of its many spin-outs. Oxford was keen to point out that repeated efforts had been made to resolve the case. Oxford made proposals including various alternatives to the licence, expert determination, mediation and early neutral evaluation. No settlement has been possible." So it takes two. So I'd like to move us on a little bit, because one of the aspects that was discussed here when thinking about fairness was to do with the extent to which Mr. Jing was able to agree revenue sharing with the researchers and to be able to influence the equity decision. So I wanted to ask Ian particularly the question about when various members of a research group are discussing their expectations of equity and revenue sharing, to what extent should the university get involved in that? And the reason that I ask is that for Oxford, in regard to revenue sharing, we are completely hands-off and we say to researchers, this is for you to agree. And we ask them to write that down and sign to show that they agree. And then we'll have a conversation with them about the respective splits on the equity as between researchers collectively and university. But I know at Cambridge you have a slightly different view, so I thought it'd be interesting to air that.
No, I think this is really important because, again, this is only about the split between the people and the creators involved. And I think we all know that having alignment among people going into a spin-out or any form of deal is extremely helpful, as in a lack of alignment is a good way to increase your chances of failure. And we do in our policy have a default position that we ask the researchers to come back to us with a proposal, and we'll normally go with that. But there's a default after a certain number of days. We can just say we're going to split any spoils that are due to you as a collective N ways when there are N people. But this is not necessarily very helpful because one of the things I think we're very cognizant of is we sometimes see strange balance, difficult power balances. You might have an overbearing PI. You might have a more junior researcher who has maybe not fully understood the greater context in which they're working and has overvalued their contribution. And so it's maybe we don't take a full hands-off approach in that. And clearly, if they get on well and they come back and it looks fundamentally reasonable, we'll just go on with it. That's fine. It's almost like could make things worse when they look good. But actually, we do have this take this slight duty of care thing, which is everybody being looked after reasonably? Is everyone understanding what the contribution may or may not be? So whilst we don't go in and mediate, whilst we don't go in and prescribe, we do actively get involved in that conversation if we see there are tensions. And we don't have that many tensions, but you do have a few tensions. It's better, our view is it's better to be involved early and help them through that process and not dictate what they should have, but help understanding. And again, it's providing information and experiences often helps people come to a reasonable conclusion.
Mark?
So there's two interesting points here. The first is, do you need an outside person to help help the academics decide amongst themselves what the share should be? And as Ian says, the power dynamics between the individuals may be different in every case. But I have been involved in inventorship disputes where there have been two PhD students feeling that this supervisor was claiming IP that wasn't really entitled to. And I felt the university did not stand up to the professor who refused to engage in meetings with an external patent attorney to consider this issue. And so I have experience where it doesn't work, and therefore I'm slightly more inclined to think, well, maybe there should be some sort of procedure, like, for example, referring it to an outside expert to decide if the parties can't agree. And then the second point is something that I find quite interesting in this Oxford case is the judge said it was perfectly legitimate for the inventors, in quotes, to share amongst themselves revenue, even though they weren't all necessarily named on the assigned IP. And that kind of triggers me a bit because I can see the argument for it, but on the other hand, I thought this was an assignment and revenue sharing agreement where the two things were linked. The IP that's being assigned is then what you share revenue on. Whereas if you can actually say, well, actually, we can give the professor 50% because it's his larger project, that troubles me as well. So
2 points. We have, in extremis, we have gone and got advice from external people. That's we do it rarely, but you should do it and be willing to do that because it can take the heat out of it. But we only share revenue on the basis of who the creators were legally, but we are slightly different to Oxford, but we have quite a strong culture of, they can say where they would like that revenue shared. And we commonly see people saying, oh, please, can this postdoc who's not an inventor, can you give them this percentage? Or can we see... And people are surprisingly generous, surprisingly often. But again, it's through consultation that you get there rather than coercion or legislation or someone just walking in and saying, this is the way it ought to be. And it's all about relationships, maintaining those.
Yeah, I mean, I'd just like to chime in that personally, I also think it would be prudent to have some mechanism, at least to sort of raise an eyebrow if something looks a bit odd, and to provide some external dispute resolution. I mean, it's quite easy to go to an IP barrister and ask them to resolve that sort of dispute, and then you're effectively, covering yourselves. Because I think we have to be aware of these sorts of power dynamics in all settings.
Fantastic. We've got not very many minutes, and I want to do a call to action. Is it a quick one, David?
Well, it was a quick one about inventorship.
Just a second, please.
Oh, sorry. Did I understand you earlier to say that the 2 of the 3 inventors were prepared to remove their inventorship off the patent? And I thought that's a rather dangerous thing to do.
No, sorry, I may have explained very poorly. But effectively, on the first patent family, there were 3 inventors, Professor Kapanides, Dr. Crawford, and Bo Jing. And on the second patent family, Kapanides and Bo Jing. And obviously, when they first brought their case, not only did they have to win on Section 39 and the unfair contracts terms, but they also had to establish that Bo Jing was the sole inventor. Because if he wasn't, there was no dispute that the university would have been at least partially entitled to the inventions because of Kapanides and Dr. Crawford. And as I say, and it's another reason why perhaps it's fine to have a sort of broader penumbra of who's entitled to revenue sharing from the invention, because actually resolving questions of inventorship can get extremely complicated extremely quickly. So we just took the view that for pragmatic reasons, to keep the case sensible, sensibly sized, we would say you can proceed. You can decide this case on the basis that Bo Jing was the sole inventor of everything, but we don't accept that's the case. And obviously, there's been no rectification of the patent register and no formal change to the inventors on the patent itself.
Yeah, I'm sorry, we're just about out of time, and I want to finish with a call to action. So I'm around for the rest of today, but sadly not over lunch because I've got somewhere else to be. But Tess, I think, is around. Mark, are you around over lunch? Yeah. And my colleague Sarah Deakin is in the audience and is here over lunch. Sarah, can you wave? Because Sarah is... Thank you, Sarah. Sarah knows all there is to know about the case and did an awful lot of the legwork behind the scenes. So, we can follow up and continue this discussion. But I just wanted to close the session by asking each of you for your sort of one top action that you should do leaving this session when you go back into your day jobs. What should be done?
I mean, personally, I would dust off that IP policy and have a careful look at it.
So beyond that, I would say make sure your activities around checking your diligence and how you're monitoring licenses, and you're doing that in a constructive and in a timely, regular basis. Make sure you've got that in place.
I can't think of a third one off the top of my head, but I agree with the previous 2. I've been amazed over the years how many universities, once an agreement is signed, it goes into a black hole, and nobody actually has ownership of managing the licensing relationship. To my mind, that's just as important as doing the deal, but it's the sexy thing is doing the deal, and then everyone forgets about it, and you discover 7 years later, a product's actually come onto the market. Nobody's actually checking whether or not any royalties are being paid. And that's just a ridiculous way of doing business.
So my third one would be, no, seriously, make sure when you do your day job and you're talking to potential inventors and about this stuff, you do explain in words of one syllable about what the consequences are of all the parts of this process, both IP and other. It's because it's maybe yours and my day job, bread and butter, and we kind of know it and we can see the future. We know the process and where you might land up. Most of them don't understand that. Take them through that mental journey. It's really worth the time. And be prepared to have to do that several more times along the way because people forget.
Fantastic. Well, I'm going to close with some thank yous. I know there are questions that we haven't been able to answer, so I apologise for that. But can we thank our panel, please? And I also need to acknowledge a whole pile of people. This is, a team endeavour. So Sarah I already called out, but our lawyer at OUI, Paul Northwood, many others behind the scenes. This is a project that spanned 10 years, so there have been a number of project managers over that time. OUI leadership deciding in these key points to go forward, to not go forward, to settle, to not settle. Support from the university was essential. We could not have done this without buy-in right to the very, very top of the university. I also acknowledge our barristers, Tom Aiken and Lee Finch, who did an outstanding job for us in court. And finally, I'd like to thank all of you for turning up and making this a really engaging and interesting session. So please give yourselves a round of applause.